All right, guys. So for this section, we're going to be talking about the other types of remedies that you can get in contract law. The main one is a thing called specific performance, which I've alluded to earlier in this subject, and possibly has been alluded to in semester one as well. That's that idea of seeking some remedy in equity in order to make the other side do what they say they're going to do. It sounds pretty awful when I phrase it like that. And as you could imagine, there are some pretty strong rules around that. But the key thing to note is that equity, and in the second recording I'll talk about injunctions. Specific performance and injunctions both fall under the equities jurisdiction. And so the rules involving it follow a lot of those maxims of equity that we've explored, hopefully, both in this subject and in semester one as well. That idea of equity acting as a mechanism for fixing defects in common law rules, and it'll only apply in certain situations. So what are those situations? Well, chat will come up. Main thing to note about specific performance and equitable remedies in general, as I said, the two main ones we'll talk about today are specific performance, and then later it'll be injunctions. But these basic principles apply to both. And that the default rule is, in contract law, you get money. Money solves all problems, or at least most of them. And as such, it's only in certain, usually quite narrow sets of circumstances where common law damages are either impossible to calculate or are just inappropriate, in many ways manifestly inadequate. Then you can get some sort of remedy from the court making people do things, and that can only be done in equities jurisdiction. It's for things that fall between the cracks. And so there's a variety of things you need to know about these equitable rules and these equitable situations when they're going to apply. The first one is true of all equitable remedies that you can seek. This includes specific performance as well as injunctions and declarations. That is that it is what's known as a discretionary set of remedies. That is different and distinct from common law and statutory actions. If you go to the court and you prove on balance of probabilities that another party, for example, is a person, is in trade and commerce and is engaged in conduct which is misleading and deceptive, you can get remedies by right. If you can demonstrate some of the common law vitiating factors, for example, that common mistake applies or common law duress, you're going to get a remedy. That's not how equity works. Equity is a series of discretionary rules. And you may have learned this from Rachel as well. The idea of equity is that it does the minimum required to do justice in a particular set of circumstances. So a person bringing that action is only going to get some form of relief in situations where money just doesn't cut it. And as I said, the circumstances where this arises is usually pretty narrow, except for one thing, which I'll get to in about 10 minutes or so. Right, so that's equitable remedies generally. That's just an introduction to this. And we're going to talk about the bulk of this recording about specific performance. That is a legal technical term to describe a remedy whereby you make or ask the court to make somebody do what they said they were going to do. And when I say that out loud, it does in many ways sound kind of awful. That idea of making people do things in situations where they've entered into a contract and for whatever reason they don't want to perform their side of the bargain. As you could imagine, this could create some sort of strange situations, and as such, specific performance is only granted in quite narrow sets of circumstances. And I've just made a note there that the mechanism that they use for determining whether or not specific performance is going to be an adequate remedy or not is when you go to court. It's nothing to do with the date of the contract or any form of breach. One of the things about equity, which is really, really important, is that because it's a discretionary remedy, it can only be granted by the court itself. You can never assume that you will be granted an equitable remedy. Much like when we talked about the vitiating factors, undue influence and unconscionable dealings. If you're taking an action under those areas in law, you can never be guaranteed that you're going to get them. And the reason for that is the courts actually look at your own conduct as part of that. Common law remedies, your own conduct, it doesn't usually matter. In equitable remedies, your own conduct does matter. Equity is a court of conscience, and as such, the parties must come to the courts that used to be called the courts of chancery, and must do so with clean hands. Now, what is specific performance? It usually is granted in situations where there is something unique or special about the subject matter of a contract. That is the most common situation this will arise in. Okay, and so as an example, the case of Falke and Gray, that involved some unique Ming Dynasty vases. Vase? I'm not sure. My Kiwi accent's not sure on that. And there, as part of the contract to sell, these very, very valuable and completely unique items of personal property were demanded by the other side, by the purchaser. And I think Falke and Gray is a good indication of the sort of circumstances where the courts look at the conduct, in this case the conduct of the purchaser, because they looked at the amount that the purchaser was paying. It was paltry, a very, very small fraction of what they were worth. The seller decided they didn't want to go through with it. Look, they're in breach of contract. Yes, they have to pay compensation. They didn't want to give over the vases, and so the purchaser sought specific performance. And in that situation, the courts of chancery said no. The reason for that is that you were trying to do the dirty on the seller. You wanted to get these at a massive undervalue. This is a court of conscience. We won't stand by that. And specific performance is refused. Now that's the case with unique items of personal property. It's a pretty rare set of situations, circumstances where that comes up. The same argument, though, can be made where things are scarce. Dugan and Lay was a case that was heard just after the war. It involved the purchase of a taxi business. So essentially a taxi plus a license to operate that taxi. And as part of this contract, when the vendor decided to not go through with it, this went all the way to the High Court, and the High Court said that, look, in that situation, there were about 700 taxi licenses in all of Sydney. These were a scarce, rare thing, and as such, there's no mechanism for the purchaser to go to the open market. There's no way they can go and buy another one of these from a third party, be compensated appropriately. As such, specific performance is an appropriate and adequate remedy in those situations when the vendor defaults. Now, there is one peculiar area that comes up quite a lot. This is the main situation where specific performance will arise for most of you in legal practice. And it flows from the idea in our legal system that all packets of land are unique. And whenever there is a conveyance or a contract for the sale and purchase of land, that land is unique. And as such, specific performance is an appropriate remedy when the vendor doesn't want to go through with the contract. If any of you have purchased real property or been involved in it at some stage, you'll know that for example, a residential transfer of residential property standard form, which I think was up to about version 16, it's issued by the Real Estate Institute of Queensland. And the standard form contract will have a component in it that deals with how specific performance will operate. So even though this is a remedy that you can seek under equity, you can, as part of the contract, actually map out how this is going to work and what circumstances specific performance can be sought. Because as a vendor, if you change your mind, the courts, in most circumstances, will uphold the rights of the purchaser to go through with that sale. So you need to leave that one in the back of your mind, because specific performance is most commonly associated with this area of law. That's really the place where it's going to come up the most in your legal practice. It can also come up, again, I've mentioned this at the bottom here, benefits to third parties. That's to do with the doctrine of privity, this idea of privity of contract, that normally third parties can't go through and enforce contracts. But in some narrow circumstances, courts can compel one party, and the action has been brought by the other side, to actually confer that benefit. And as I'll explain afterwards, later in this thing, you can actually, in some circumstances, substitute what we call equitable damages, either in conjunction with or in replacing in order for specific performance. But we'll get to that a little later. Okay, so that's the main situation. Those are the two main ones where specific performance is most likely to be granted, particularly sales for land. Yes, we, in terms of the academic world, will from time to time assess you guys. It's possible that in your exam you'll be assessed on a unique item of personal property, but for the 99.9% of the time, specific performance comes up for sales, purchase and sale of land. Okay, another thing to note is that equity is a court of conscience, and it is designed to resolve defects in the common law. And so there can be some situations where an order for specific performance is most appropriate if the damages can't be ascertained And that's going to cause, either through that or again to do with time constraints, either of those things are going to cause some grave injustice. And so this White and Haberdan matter involved some property developers and the seeking of finance. And the financier got cold feet on this for one of the developers and decided to pull the finance. And in that situation, the person seeking finance was in a spot of bother because there was no guarantee they were going to get finance again, and even if they would, it was very unlikely that it was going to occur in the timeframes that were required to complete the contractual obligations for the development. And that was a set of circumstances where, in this case, the New South Wales Supreme Court was willing to grant an order of specific performance to make the lender lend the money. Again, it's usually quite a narrow or unusual set of circumstances where that'll happen. Another set of unusual circumstances is when a person to a contract has no money but does have property. And again, property of the contract. So that if, again, a person sells an item of personal property, refuses to go through with that particular transaction, say a boat, for example, you can bring a common law action for damages, but if that is going to be futile, again in quite narrow circumstances, this is quite an old case, the court will grant specific performance in order to achieve some form of justice in that situation, particularly when parties are sort of deliberately going through and being frivolous with their money. In those situations, courts can compel the other side to convey that item of personal property or to land. All right, so there's a couple of rules that we really need to note here. All right, first thing to note for an order of specific performance, and in fact all remedies under equity, is this shift from sufficient consideration to valuable consideration. This concept, I'm going to go through with this with you guys now because this will come up again in commercial law settings and in trust law. Because you may recall Rachel Bradshaw's very final lecture that we came along, I think I came along with a little painter, a little frame, and it just had a peppercorn in it. And that's because a judge said a long time ago, 20 years ago, I actually don't remember the case, a peppercorn is sufficient consideration in contract law. In contract law, we don't care about the fairness of it, in common law anyway. We don't care. If two parties are coming together with no defects in their mind or knowledge of the circumstances, none of these vitiating factors, and want to exchange something which is intrinsically valuable for something which intrinsically is not, the courts of common law throw their hands up. It's not about the quality of the bargain. That's not the point. Contract law is about upholding the bargain itself. That is how it works at common law. That is not how it works in equity. In equity, the courts look at the size, the amount, the inherent value of the consideration that passes between the two parties. So, for example, in Barton Official Receiver, contracts made under seal, a contract that is done through what's called a deed. A deed is a statutory instrument. It's a document that is signed, sealed, and delivered. And that document bypasses consideration in common law. I'll say that again. Contracts can exist using what's called deeds. A deed is an instrument that is governed by statute that allows the bypassing of consideration. What does that mean? It means that if I want to have a contract with Raz to sell her my boat, and I want this governed by contract law, but I don't want her to provide any consideration, I can enter into a deed, a solemnly sworn document that must be stamped, witnessed, and delivered, which is the act of completing the deed. It's not, strictly speaking, posting it. That will bypass the need for Raz to provide consideration. Deeds, and again, it's possible that Rachel talked about this in Contract 1. Excellent. Deeds bypass common law requirements for consideration, but they don't bypass this idea of valuable consideration in equity. They're a bit of a hack, you might say, in contract law. And so if you are seeking a remedy in one of the equitable remedies, and here in specific performance, if there is this deed, right, and I've entered into it, Raz hasn't provided consideration, she can sue in common law. She can sue for damages because her need for consideration has been bypassed. But she can't sue for specific performance. She can't seek that as a remedy because she hasn't provided valuable consideration as part of that process. Okay, so that's that thing you need to note. Situations, you have to look at the adequacy of it. If my boat was worth $10,000, she paid $200, she cannot get specific performance. It doesn't have to be perfectly fair, but it must be valuable relative to the thing that's being purchased. Okay, there are some other situations where specific performance really isn't going to work. The most important one of these are contracts for personal service. Slavery is not okay, and enforcing contracts, making people work for other people, is very far removed from our legal system. Lumley and Wagner involved an opera singer. It's the same guy from Bettina and Guy. There's a few cases around in the mid-1800s. And this particular contract was for a German opera singer to come and sing and not sing for any of his competitors at that particular time. And so there the courts went through and analysed and talked about this idea of forcing people to work for other people, and made note in that situation that having her arrive and insisting on seeking permission for her to work elsewhere isn't actually the same as forcing her to sing for him. She still had the option of going home, going back to Germany, or singing anywhere else on the continent for that matter. She could also engage in other forms of work, promotional work, or theatre. So just make note, this is a reasonably important rule. It doesn't come up much because you guys, as your legal education, it's one of the rules that you'll learn. Tick that box in your head. And probably never revisit this until somebody asks you if you can make somebody turn up. And the answer is no. Question?
Would this still apply if the work was for a unique item? Just like a painting, someone commissioned someone to paint this special and unique painting.
Kind of. So
still apply, you cannot get someone specifically to perform something.
So the question is, would this apply if it involved a an aspect with a particular unique item. So there, I think the question involves a personal service in combination with an item, so that you must turn up and you must personally deliver me that. It's actually to do with the nature of specific performance as a remedy. Specific performance must be granted for the entire contract. In the next recording, we'll talk about injunctions. They can be granted for specific aspects and parts of a contract. Specific performance has to be for the entire thing. So if a component of a contract involves personal service, they won't grant it. They won't let that. It won't fly, even if there was a unique item as part of that. Supervision. This is really a policy reason for not granting specific performance, and it also applies to other areas of equitable remedies as well. Supervision is where the court would have to go back and check whether or not a person was complying or not. So that if there was, for example, again, that Argyle stores case, if there was a lease for some buildings and there had to be some a maintenance contract to go through and repair these things, to prepare them and to keep them open, make sure that they were open for certain hours. The court in those situations would actually be forced essentially to have to go back and check all the time. And as such, they won't order specific performance in those situations. They will make an order for damages instead. And again, in the next recording, we'll talk about equitable damages. But if it's going to require the court to supervise this, in other words, usually when the courts don't literally go out and look and wait and see, it would require a party to keep going back to court. That's the key indicia of determining whether or not a grant for specific performance will be made. Would one or both of the parties need to keep going back to court when the other side determines that they're not going to do this? Because in equity, if you are granted specific performance, the default rule, the default thing happens if you just choose to not do it anyway. Does anyone know what it is? It's contempt of court. You can go to jail. So going back to the Ming vases or the taxi license, if you're ordered by the court to do specific performance and you still don't hand up the vases or the taxi license or some other item, unique item of property, it's contempt. You can be put in jail for doing it, for not doing it. And the bailiffs can come around and grab your stuff. Okay, another situation that will arise where courts won't grant specific performance is when both sides aren't on an even footing and can't both enforce the contract. And the classic one of this is contracts involving minors. So minor is not, other than contracts for the necessities of life and beneficial contracts for service, minors can enforce contracts themselves, but they can't be enforced against them other than those two areas. So as such, specific performance can't be ordered by either side if one of those parties is a minor. And there is a mechanism around that, though, which came up in Kell and Harris, is that you wait until the minor turns 18. And then you can go and seek specific performance, although that's subject to the next slide. Another situation where specific performance won't be granted is if, for whatever reason, the contract can't be enforced in the courts anyway. And so there are two sections in the Property Law Act. You can Google them if you want to. For those that haven't yet done land law, you'll get to know those sections. There are two types of contracts that must be in writing. contracts that are guarantees, and contracts for the sale of land. They must be in writing, and if they're not in writing, the contract can't be enforced, or it can't be enforced at common law, and as such, specific performance can't be granted in those situations. If the thing can't be granted against one or both parties, the courts won't grant the order. Okay, one of the important, what we call them, bars, we call them when we're talking about bars to rescission. You guys might recall when we talked about the remedies that you can seek for undue influence and unconscionable transactions. When you go to court and argue those things, we talked about these bars to rescission. One of those bars is delay, taking too long. Equity assists the diligent, not the tardy. And as such, if you take too long to enforce, in this case specific performance, as a remedy, the courts won't grant it to you. And again, it's really to do with disadvantage. This idea of it creating more of an injustice by you delaying than the injustice which is caused by you not being granted a remedy in specific performance. It's really about a balancing act here. And so while, yes, there are some statutory mechanisms in terms of seeking orders, for example, you may or may not be aware of the Limitation of Actions Act, Section 10, says that you have 6 years to bring an action in tort, contract, or quasi-contract. And equity follows the law. So if your delay is going to create some injustice for the other side, usually the courts won't grant specific performance. I'll note that other than that 6-year rule, which is statutory rule, it's difficult to ascertain how long is too long. And that is kind of the result of the fact that equity, or the court's equitable jurisdiction, is inherently discretionary. The conduct of the parties matters. Taking too long counts against you, especially if it creates some form of injustice or prejudices the other side in some way. And so similarly, this idea of what we call the unclean hands doctrine, that is where you have performed some sort of poor conduct in regards to this transaction. And one of those things in contract law is repudiating it. And so that if you have demonstrated an unwillingness or an ability, but particularly unwillingness to perform, then the courts at some stage later are much less likely to grant you specific performance if, for whatever reason, the contract hasn't been terminated. In other words, if the other side has kept the contract on foot. So you've demonstrated an unwillingness. If, for whatever reason, the other party keeps it on foot, later on you want to enforce specific performance, the courts, your conduct is going to count against you. In equity, how you treat the other side, and particularly how unscrupulous you act, whether you do things in good conscience, these factors are taken into account when the courts are determining whether to grant you an equitable remedy. Similarly, hardship. It's a court of conscience. If specific performance is going to create grave hardship for the other side, courts won't grant it. So going back to again, the contract between Raz and myself, let's just assume that she's buying my boat, but I've got no other money, and the boat is all that I use to earn my income. For whatever reason, I was silly and I went and I sold the boat. She wants specific performance of the boat because it was a particularly good deal. In that situation, the courts are unlikely to order specific performance if that hardship which occurs is going to lead to some injustice. And the final thing to note here is I've put under the category of vitiating factors, but there's a variety of things going on here. And that as well as the conduct, in other words, if the other side acts unconscionably, the courts are not going to grant an order of specific performance if it's futile, if it's pointless. And that can happen for a variety of ways. Again, the subject matter is destroyed, or the foundation of the contract has been wholly undermined. If the grant is impossible, if the subject matter can't be found, or it's outside the jurisdiction, or the order itself to do the transfer is going to be unlawful. If there was a contract for the purchase of a deregistered motor vehicle, for example. So that in these sort of situations, and I've done a broad spectrum of areas, but the key thing to note is that equity doesn't do anything futile. If there's no point in granting an order, they won't grant the order. It's discretionary in nature. It's not the same as common law orders. Remember, I made the point about a breach of contract, in theory, always entitling you to at least nominal damages. This is true. You can go to court and vindicate your rights, much like in tort, the tort of trespass to the person. If somebody slaps you and you suffer no harm, maybe a little bit of hurt feelings or humiliation, they'll award you $10 and tell you to go away. That's not how things work in equity. Equity won't grant remedies as of right. Nothing is actionable per se. There must be some sort of injustice that needs resolving in order for them to grant a remedy. And so specific performance in those circumstances won't be granted. Blomley and Ryan, for example, that was a case that we talked about when we were talking about unconscionable conduct. There it was the old guy who had a farm. He was well known to be an alcoholic. And so the local graziers arrived with 2 bottles of rum. They all got drunk, and then he signed the property over to them. One of the things that came up there is that the order that they were seeking was specific performance. And there the court said, no, you can't get specific performance because your conduct was unconscionable in regards to this transaction. You acted against really the core tenets of equity in regards to that. And we won't grant that order in that situation. The refusal to grant specific performance will arise in situations where a party is acts unconscionably, although it can also arise, in other words, the grant might not be made, even if the contract itself hasn't been vitiated, for example, through delay. So in other words, you could make an argument that a particular contract would have been subject to unconscionable conduct or undue influence or something similar, but for whatever reason, that you don't get up on the vitiating factor to undo it. But if the land in that situation hadn't been conveyed, the courts might just award damages and not make you convey the property. In other words, they've refused to order specific performance as a result. Okay, so I'm going to change the slides at this point. Specific performance is obviously it's an equitable remedy. It doesn't come up that much but it is actually something you do need to know about. It's a legal, technical term. It needs to be part of your repertoire. It's a remedy that can be sought, usually in very narrow situations, but most commonly in regards to the land. And so you need to know when people are using the term specific performance, particularly in regards to land transactions, what that means in that context. And so I'll leave that recording there. We'll take 5 minutes, an early break here, and I'll come back and do the rest of it in a second after switching.